Before we begin, a quick and important disclaimer. The following content is intended strictly for educational and entertainment purposes only. Divorce laws in the United States vary significantly by state, county, and individual jurisdiction. The information discussed here does not constitute legal, financial, or tax advice. I am not an attorney, and nothing in this video establishes an attorney-client relationship. Family law is complex, and outcomes in divorce proceedings depend on the specific nuances of your local statutes and individual circumstances. You are strongly encouraged to conduct your own due diligence, consult with qualified legal professionals in your specific area, and rely on official court documentation for any decisions regarding your personal life and assets. If you are a man living in the American suburbs, the house you live in, the neighborhood you walk your dog in, and the life you have methodically built over the last decade are currently sitting on a foundation that is significantly more fragile than you realize. You might think your situation is unique, that your marriage is safe because you pay the mortgage on time, attend the soccer games, and maintain the lawn, but the reality is that the suburban divorce machine does not discriminate based on your level of contribution. Every single year, hundreds of thousands of men in your exact position wake up to a reality they never anticipated. A formal legal notification that irrevocably alters the trajectory of their net worth, their access to their children, and their social standing within their own community. Most men wait until the moment the envelope hits the table to start learning the rules of the game, and by that point they are already playing from a massive structural disadvantage. This series is not a guide on how to survive a divorce. It is a deep dive masterclass on understanding the systemic reality of the American divorce process, so you can navigate the path ahead with eyes wide open. You are here because you need to understand the mechanics of the system before you find yourself caught in it. For many suburban men, the divorce process is not just an emotional earthquake. It is the single most expensive and disruptive financial event of an entire lifetime. The problem is that most men view marriage as a romantic union or a social partnership, while the state views it strictly as a legal and economic contract. When that contract is dissolved, the dissolution does not operate on fairness or meritocracy. It operates on precedent, state-specific statutes, and the strategic positioning of assets. If you do not understand how these factors interact within the suburban context, where assets are often tied up in illiquid property and complex retirement accounts, you are walking into a high-stakes negotiation with no leverage. Consider the baseline data. While national divorce rates have fluctuated, the socioeconomic impact on middle-class, suburban households remains severe. When a dual-income suburban household splits, the sudden need to maintain two separate residences, each at a standard of living that mirrors the original, creates an immediate, crushing financial pressure. In many states, the court's primary directive is to maintain the status quo for the parties involved, which often translates to a rigid redistribution of assets and income that can leave the higher-earning spouse, frequently the husband in many traditional suburban setups, struggling to remain solvent. We are talking about the potential for long-term alimony obligations, the division of 401k accounts that were intended for your retirement, and the complex reality of property division that goes far beyond simply splitting the equity in your home. This masterclass is designed to solve the critical gap in knowledge that leaves so many men blindsided. We are going to deconstruct the myths of the courtroom, analyze how suburban lifestyle markers like property equity and pension funds are treated during a separation, and clarify the distinction between the emotional narrative of your marriage and the cold, hard procedural reality of a family law court. Many men assume that if they are the primary breadwinner, they will be penalized, or conversely, that if they are the primary caregiver, they will have the upper hand. Both of these assumptions can lead to catastrophic tactical errors. The system is indifferent to your moral standing. It is concerned with the statutory requirements for child support, the equitable distribution of marital assets, and the determination of spousal maintenance based on a formulaic assessment of income and expenses. We are going to move through this step by step. In the coming segments, we will examine the pre-divorce landscape, the importance of financial documentation, the psychological dynamics of the negotiation process, and the specific pitfalls that suburban men often stumble into during the discovery phase. You need to understand how to audit your own financial life before anyone else does. You need to understand the difference between a contested and uncontested filing, and why the speed of your initial response can dictate the tone of the entire proceeding. We will look at case studies that illustrate how different states handle the division of assets, exploring how community property states differ from equitable distribution states, and what that actually means for your bank account. We will discuss the reality of living arrangements during the pendency of a divorce, and why leaving the marital home prematurely can sometimes be interpreted as abandonment or a waiver of certain rights. This is not about fighting a war. It is about protecting your future through an objective understanding of the law. If you are currently feeling the stress of a deteriorating relationship, you are likely operating under a cloud of cortisol and emotional exhaustion. That state of mind is exactly what the system is designed to capitalize on, or at least what makes you most susceptible to making poor long-term decisions for the sake of short-term relief. The suburban middle-class trap is characterized by high debt-to-income ratios, significant home equity, and complex investment portfolios. When you add the complexity of childcare and the potential for long-term support obligations, you have a situation where a single bad day in mediation can cost you a decade of retirement savings. By the end of this deep dive, you will have a comprehensive framework for navigating this process. You will know exactly what information to gather, who to contact, and how to communicate in a way that protects your legal standing. We are moving past the surface-level advice you find on internet forums and getting into the systemic realities that actually drive the outcomes in American family courts. Stay tuned as we begin to map out the financial and procedural architecture of the American suburban divorce. The first structural pillar you must comprehend is the difference between a community property state and an equitable distribution state. If you live in a place like California or Texas, you are operating within a community property framework. This essentially means that almost everything acquired during the marriage, regardless of whose name is on the title, is considered marital property. Imagine if you are a suburban architect in 2026, and you spent the last 15 years pouring your personal commissions into a brokerage account that remains solely in your name. In a community property state, the assumption is that your spouse contributed to the environment that allowed you to earn that money, and therefore it is subject to a 50-50 split. This is the reality for millions of suburban households, where the nuance of personal effort is often secondary to the statutory definition of marriage as an economic partnership. In contrast, if you live in an equitable distribution state, the court has more discretion. The goal here is not necessarily an equal split, but a fair one. This sounds more favorable, but fair is a subjective legal term that can lead to unpredictable results. Imagine a scenario in a suburb of New Jersey where the husband inherited a family home before the marriage, but during the marriage, the couple used a joint bank account to perform a major renovation that added $200,000 in value to the property. The court might classify a portion of that home as marital property because the marital funds were used to increase its value. You are now looking at a complex forensic accounting situation where you must untangle years of commingled funds. If you cannot provide clear documentation showing the source of every dollar, the court will often default to the most conservative interpretation, which typically means a significant portion of what you thought was separate property is pulled into the marital estate. The next critical step is understanding the discovery phase. Many men view divorce as a negotiation between two people. In reality, it is a formal legal discovery process. Think of it as a complete financial audit of your existence. You will be required to fill out a financial affidavit, a document that asks for a detailed accounting of your income, expenses, assets, and liabilities. This is not a rough estimate. This is a sworn statement to the court. If you omit an account, fail to disclose a debt, or provide inaccurate figures, you are technically committing perjury. The discovery phase allows your spouse's attorney to request bank statements, tax returns, credit card logs, and property valuations from the last several years. Consider the case of a mid-level corporate executive in 2026 who had been diverting small amounts of income into a hidden crypto wallet or a separate business venture, thinking it was a rainy day fund. During discovery, his spouse's legal team uses subpoenas to track the flow of funds from the primary household account to these peripheral assets. Not only does that hidden asset get pulled into the pool for division, but the executive loses all credibility with the judge. In the suburban context, where lifestyle consistency is often scrutinized, any attempt to hide assets creates a narrative of dishonesty that can influence the judge's opinion on other matters, such as alimony or the allocation of attorney fees. The cost of legal representation for both sides is often paid from the marital estate. So every hour your attorney spends fighting over hidden assets is literally burning the capital that both you and your spouse need for your post-divorce lives. Now let us address the concept of the marital lifestyle. Judges in the American suburban court system are frequently tasked with ensuring that both parties can maintain a standard of living reasonably comparable to what was enjoyed during the marriage. This is the primary driver behind alimony, or spousal support. If you are a high-income earner and your spouse was a stay-at-home parent, the court is going to look at your monthly household burn rate. Let us imagine a couple in a wealthy suburb of Chicago. Their mortgage is $5,000, they have 2 car payments, private school tuition for 2 children, and travel expenses that total $15,000 a month. If the marriage dissolves, the court does not expect the lower-earning spouse to immediately move to a studio apartment. They will attempt to calculate a support payment that allows for a continuation of that suburban lifestyle, within the limits of your income. This is where the math becomes brutal. If your net income cannot support the maintenance of 2 separate households at the original standard, the court will force a downward adjustment for both parties. However, the supporting spouse often remains on the hook for a duration that can last for years, or even decades depending on the length of the marriage. In some jurisdictions, a marriage of 10 years or more is considered a long-term marriage, which significantly changes the potential duration and amount of spousal support. You need to understand your state's specific alimony guidelines, which are often codified in tables that use the length of the marriage and the disparity in income to determine a presumptive range. This is not a negotiation you win with charisma, it is a calculation you manage with data. Another trap is the handling of the marital home. For many, this is the most valuable asset, but it is also the most emotionally charged. Often, men will fight to keep the house to avoid disrupting the children, or out of a sense of pride. However, you have to run the numbers on whether you can actually afford it. If you have to pay your spouse their half of the equity, you are essentially buying the house a second time. If you cannot refinance the mortgage in your name alone, or if the monthly payments consume 60% of your take-home pay, keeping the house is a strategic error. You are essentially anchoring yourself to a depreciating asset that limits your liquidity and keeps you tethered to a previous life. We are currently building the foundation for your understanding of these assets and liabilities. You have seen how property is classified, how discovery acts as a financial audit, and how the court protects the status quo. But there is a hidden layer to this process that most men never see until it is too late. There is an entire psychological and tactical game played during the pre-filing stage, the time before the papers are even served. Understanding how to navigate the immediate aftermath of a divorce declaration, how to handle the communication, the living arrangements, and the initial tactical positioning, is the difference between a controlled exit and a total collapse. In the next part, we will dissect the specific mistakes made in the first 72 hours of a divorce filing, and how to prevent yourself from losing your position before the first hearing even begins. The first 72 hours following the moment a divorce is declared are not just emotionally charged. They are the most dangerous period for your legal and financial future. Most men, caught off guard and overwhelmed by a surge of cortisol, make reflexive decisions that echo for years in the courtroom. Imagine if it is early 2026, and you arrive home to find your spouse has already packed a bag, or worse, has already consulted with a top-tier family law firm in your county. The instinct is to either lash out in anger, move out immediately to escape the conflict, or try to win your spouse back with promises of change. Each of these reactions is a tactical error that can be exploited by the opposing counsel. The biggest mistake men make is vacating the marital residence. This is a common trope in suburban divorce narratives, where the husband leaves the house to keep the peace. By leaving, you are not just walking away from your home. You are creating a status quo that the court may be reluctant to change. If you have been out of the house for 3 months before the first temporary hearing, the court will likely view your spouse as the primary caregiver and the person who requires the home for the stability of the children. You have essentially conceded the space. Furthermore, if you are the one who leaves, you are now responsible for your own rent or mortgage in a new location, while still being expected to contribute to the household expenses of the marital home. You are effectively paying for 2 lives while your financial leverage is being eroded. Another critical mistake is the immediate degradation of communication channels. In the modern suburban age, your digital footprint is permanent. Every text, every email, and every social media post is discoverable evidence. When a marriage ends, the impulse to vent to friends or to send emotional messages to your spouse is overwhelming. You must assume that every word you write is being read by a judge. There are countless case studies of men who, in the heat of the moment, sent messages that were later presented in court to demonstrate instability, volatility, or a lack of concern for the children. In 2026, even private messages are easily subpoenaed. You need to transition your communication to a professional, business-like tone. If you are angry, write the message but do not send it. Let it sit for 24 hours. If the message does not serve your goal of a fair outcome, it should never be sent. You also need to understand the concept of temporary orders. These are the rules that govern your life while the divorce is pending. They cover who lives where, who pays which bills, how the children are scheduled, and the initial allocation of access to marital funds. Because these orders are temporary, many men do not realize how difficult they are to overturn once they are established. If you agree to a temporary order that leaves you with limited access to your children or a financial obligation that is unsustainable, you are setting a precedent. Judges prefer stability. If a temporary arrangement has been working for 6 months, the court is often inclined to make it permanent. You must approach these initial negotiations with the same intensity as the final settlement. Consider the scenario of a marketing director in a Connecticut suburb. He agreed to a temporary parenting plan that gave him every other weekend, thinking he would negotiate for more time later. By the time the final trial date arrived, his spouse's attorney argued that the existing arrangement was the status quo and was working perfectly well for the children, despite the father's protests that he wanted more involvement. Because he did not fight for an equal, or at least more substantial, schedule in the first 30 days, he spent the next decade fighting a legal battle just to increase his time by a few days a month. The temporary phase is not a transition. It is the blueprint. You must also begin the process of document collection immediately. This is the stage where you secure your financial safety. This involves gathering tax returns for the last 3 to 5 years, bank statements for all accounts, investment account summaries, retirement plan statements, and mortgage documents. If you have access to a shared digital drive or a cloud account, copy everything to a secure, private location that your spouse cannot access. Do not wait for the formal discovery request. When you are served, you will have a limited amount of time to provide this information. Having it organized, digitized, and ready for your attorney not only saves you thousands in legal fees, but it also gives you a clear picture of your actual financial net worth before the negotiation starts. This process is not about hiding money. It is about transparency and accuracy. It prevents your spouse from being able to manipulate the numbers to create a false narrative of your financial status. If you are a high earner, you must be prepared to defend your income and your business assets. If you have equity in a private business, you will need a formal valuation. If you have stock options or restricted stock units, you need to understand the vesting schedules and how they are treated in your state. Every piece of financial data you possess should be treated as a strategic asset. While you are managing the logistics, you also need to manage your environment. If you remain in the home, set clear, firm boundaries. The separation of your professional life from your personal life during this period is essential. You need to focus on your work, your physical health, and your mental clarity. The system is designed to wear you down, and the men who prevail are those who maintain a consistent, composed, and rational demeanor. Do not engage in arguments in front of the children. Do not use the children as leverage or as pawns in your negotiations. Courts are extremely sensitive to any hint of parental alienation, and any evidence of such behavior can have severe consequences on custody arrangements. You are now beginning to see that the early days of divorce are a game of inches. You are securing your legal footing, protecting your financial interests, and establishing the professional tone that will carry you through to the final decree. But there is a massive trap waiting in the wings, the legal representation trap. Many men believe that hiring the most expensive, aggressive shark in town is the key to winning. In reality, the legal system has a way of neutralizing that approach, and sometimes the most aggressive path is the most expensive and least effective. In the next part, we will break down the myth of the courtroom shark, explain how to select legal representation that actually aligns with your goals, and show you why a strategic negotiator often outperforms a courtroom fighter in the suburban American divorce. The myth of the legal shark is perhaps the most expensive delusion in the history of American family law. Many men enter the divorce process believing they need to hire the most aggressive, loud, and expensive attorney they can find, assuming that the courtroom is a battlefield where the side that fights the hardest walks away with the spoils. In reality, the legal system is a structured, procedural, and bureaucratic process that thrives on predictability. Judges generally dislike volatility, and they are not impressed by attorneys who turn every minor point of contention into a dramatic, billable hour circus. Imagine if you are a mid-level manager in a 2026 suburban landscape, and you hire a litigator who spends $5,000 in fees arguing over who keeps the kitchen appliances. That money does not disappear. It is extracted directly from the marital estate, the very pool of assets that you and your spouse are supposed to be dividing. When you choose an attorney, you are not hiring a gladiator. You are hiring a settlement strategist. Your objective is not to destroy your spouse. It is to reach an equitable outcome that allows you to rebuild your life without being financially crippled by legal fees. A strategic negotiator understands how to prioritize the issues that actually impact your long-term future. They understand that winning an argument over a piece of furniture is a net loss if it costs you $2,000 in attorney time. Instead, a skilled negotiator focuses on the big picture issues. The structure of the parenting plan, the valuation of the primary residence, the allocation of debt, and the duration and amount of spousal support. These are the items that define your financial health for the next decade. Consider the case study of a software engineer in a suburb outside of Seattle. He initially hired an attorney who thrived on conflict, frequently sending inflammatory letters to his spouse's counsel. Within 3 months, he had exhausted $20,000 in legal fees, and his spouse responded by hiring an even more aggressive firm, leading to a tit-for-tat escalation that stalled all progress. The judge, seeing the lack of cooperation, eventually imposed a rigid, unfavorable parenting schedule that neither party liked, simply because the court grew tired of the constant, petty motions being filed. This man eventually switched counsel to a mediator-minded attorney who understood the local court system. This new attorney spent 2 sessions directly with the opposing counsel, identifying the 3 core issues they actually disagreed on, and settled the case in a fraction of the time. The contrast is clear. The aggressive approach burned capital and stripped him of his agency, while the strategic approach focused on the outcome. Selecting the right counsel requires you to look past the marketing and the confidence of the initial consultation. You need an attorney who is familiar with the specific judges in your county. Every family law court has a unique culture. Some judges are known for strict adherence to statutory formulas, while others are known for their preference for creative, custom-built agreements. An attorney who knows these nuances can provide you with a realistic assessment of potential outcomes. They can tell you, based on historical trends in that specific courtroom, what a judge is likely to decide regarding alimony or asset division. This allows you to make informed decisions rather than gambling on the hope that you will find a sympathetic ear. One of the most important questions you should ask a potential attorney is how they handle the settlement process. Are they interested in trying to resolve the case through collaborative law? Or is their default setting to file motions and wait for a trial? You want someone who is comfortable in the courtroom but views trial as a last resort, not a default starting position. A trial is the most expensive and least predictable path you can take. It hands the decision-making power over to a third party who knows nothing about your life, your children, or your financial goals. A settled agreement, negotiated between the two of you with the guidance of counsel, gives you control. You are the architect of your own post-divorce life. Another critical factor is the size and structure of the firm you choose. A massive high-overhead firm might assign a junior associate to your case, meaning you are paying premium rates for someone who is still learning how to navigate the court system. On the other hand, a solo practitioner might be deeply experienced, but could be overwhelmed if your case becomes complex or requires extensive financial discovery. You need to assess the workload and the level of personal attention your case will receive. You should be looking for a middle ground. An attorney with established experience, a reasonable caseload, and a clear, transparent billing structure. Understand that your attorney is only as good as the information you provide. If you are disorganized, if you omit facts, or if you hide assets, your attorney cannot represent you effectively. They are not magicians. They are officers of the court. Their ability to negotiate is entirely dependent on the leverage you provide through your financial documentation and your adherence to the procedural rules. You need to be a partner in your own representation. Keep detailed notes, maintain a clean digital archive of every correspondence, and be honest with your legal team about your goals and your fears. If you are terrified about losing access to your children, say that clearly. If your priority is keeping your business intact, state that up front. We are currently deconstructing the professional layer of your divorce, moving past the emotional noise to focus on the reality of legal advocacy. But even the best attorney cannot protect you if you fail to understand the most dangerous aspect of the suburban divorce: the social and psychological fallout. Divorce in the suburbs is a public event. Your neighbors, your children's school, your social circles, they all become part of the environment in which your divorce plays out. How you handle your public presence, your privacy, and your social interactions in the middle of a legal proceeding is a tactical battle that most men lose before it even begins. In the next part, we will explore the social minefield of the suburban divorce and explain how to protect your reputation and your privacy while the legal gears are turning. The suburban landscape is an ecosystem built on social cohesion, predictable routines, and shared community values. When a divorce occurs, it is not merely a private legal dissolution. It is a visible rupture in that ecosystem. Your neighbors, your colleagues, and even the families of your children's friends will observe the fallout. In the suburban environment, reputation is often treated as a form of social capital, and in the context of a high-stakes divorce, that capital is highly vulnerable. You must operate with the understanding that privacy is a strategic necessity, not just a personal preference. Anything you say or do in public, or even within what you perceive as private social circles, can be weaponized in the courtroom. Imagine if it is mid-2026, and you are a project manager in a tight-knit neighborhood in Ohio. You believe you are confiding in a trusted neighbor over a coffee, venting about the frustrations of the separation. That neighbor, however, also happens to be close friends with your spouse. Within hours, your unfiltered, emotional comments about your spouse's character or your own financial frustrations are reported back. In the next hearing, that testimony is used to paint a picture of you as a volatile, angry, or unstable individual. This is a common trap. People in the suburbs often love to gossip, and during a divorce, you become the primary subject. You must adopt a policy of total discretion. If you would not want a judge to hear it, do not say it, and certainly do not write it down. The social media dimension of this problem is even more severe. In the modern era, a vast majority of family law attorneys regularly scrape social media profiles for evidence. A photo of you out at a bar, a comment on a post that seems innocuous to you, or even an update about your vacation plans can be used to contradict your financial affidavits or your claims about your lifestyle. If you are claiming that you are struggling financially and need a reduction in support, but your Instagram is filled with photos of luxury dining and travel, you have provided your spouse with ammunition to challenge your credibility. This is not just about being cautious. It is about recognizing that your online persona is a permanent, searchable legal record. For the duration of your case, your social media accounts should be either deactivated or set to the strictest privacy settings, and you should refrain from any posting that relates, even tangentially, to your lifestyle or your personal life. The impact on your children's environment is another area where you must exercise extreme care. The suburban school system is often the center of family life. Teachers, coaches, and school administrators will inevitably notice if there is tension or if a child's performance changes. If you attempt to use the school as a battleground, for instance, by trying to win the support of teachers or by criticizing your spouse during pickup and drop-off, you are failing the test of parental stability. Courts are particularly sensitive to any conduct that appears to involve the children in the conflict. You must maintain a neutral, consistent, and cooperative front when dealing with school officials. The goal is to provide a sense of stability for your children, which, in the eyes of the court, is the highest indicator of your fitness as a parent. Consider the case of a local business owner in a suburb of Atlanta. He decided to confront his spouse's new partner at a school sporting event, acting on the assumption that his standing as a long-term community member gave him the authority to police the situation. The incident was documented by multiple parents, and the reports quickly found their way into his custody hearing. His spouse's attorney argued that his actions demonstrated a lack of emotional regulation and an inability to prioritize his children's well-being over his own grievances. The judge subsequently restricted his access to school events, essentially forcing him to delegate those responsibilities to a third party or a professional monitor. By losing his temper, he lost his access. This is a recurring historical trend in family law. The parent who remains calm, focused, and child-centered generally achieves better long-term outcomes than the parent who acts out of emotional impulse. Maintaining your professional reputation is equally important. Your career is the engine that will fund your life after the divorce. If you allow the stress of your personal life to bleed into your workspace, you risk your own financial stability. You need to inform your employer only what is strictly necessary. You do not need to share the intimate details of your separation with your manager or your team. Keep your professional life professional. If you find that your work is suffering, take steps to manage your stress privately, through counseling or physical activity, rather than seeking support from colleagues who may inadvertently become witnesses in your proceedings. Your ability to remain a productive, high-performing professional is a key element of your leverage in settlement negotiations. There is also the matter of your extended family and friends. While you certainly need a support system, you must be careful about who you allow into your confidence. Well-meaning friends who urge you to fight, who provide you with questionable anecdotal advice, or who attempt to intervene on your behalf can cause more harm than good. They do not understand the legal, financial, or tactical realities of your specific case. They are looking at your situation through a lens of friendship, not legal strategy. Limit your support group to professionals, attorneys, financial planners, and therapists who can provide objective, data-driven advice. When talking to friends, keep the conversation focused on your own emotional well-being and stay away from the details of the ongoing litigation. You are learning to navigate a landscape where your every move is monitored, scrutinized, and evaluated. You have learned how to protect your financial documentation, how to select the right legal strategy, and how to maintain your reputation in the face of intense social pressure. But there is one final, crucial element of this masterclass that we have yet to address: the specific, granular reality of asset division regarding your retirement accounts, your business interests, and your complex tax obligations. These are the deep-tissue financial issues that, if mishandled, can cause permanent damage to your economic future. In the next part, we will move into the complex financial engineering of your divorce, specifically focusing on how to audit, value, and defend your most significant long-term assets against the pressures of equitable distribution. The most significant financial errors made by men in suburban divorces occur when they fail to treat their marital assets as a business portfolio requiring a professional audit. You are not just ending a relationship. You are undergoing a corporate-style dissolution of a partnership where the assets are often illiquid, complex, and tied to tax liabilities that can haunt you for years. Imagine if it is early 2026, and you are a mid-career professional in a suburb of Houston. You have a 401k, an employer-sponsored stock option plan, and a portion of your income invested in a brokerage account. Most men make the mistake of seeing these numbers at face value. They think $1 in a retirement account is equal to $1 in a savings account. That is a fundamental error. The first step in your audit must be understanding the tax basis and the vesting status of your assets. A retirement account such as a 401k or IRA is a pre-tax asset. If you withdraw funds before retirement age, you face penalties and taxes. If you are forced to divide this account, you are not just splitting the current balance, you are splitting a future tax burden. If your spouse receives a portion of your 401k through a Qualified Domestic Relations Order, or QDRO, the taxes on that portion are transferred to them, but the remaining balance in your account is still subject to the compounding growth, or the lack thereof, that you have cultivated over the years. You must work with a financial planner or a tax professional to model the long-term impact of these divisions. Do not rely on your family law attorney to provide tax advice, as that is outside their expertise. Consider the complexity of stock options or restricted stock units, which are common in many suburban executive roles. These assets often have vesting schedules that extend for years into the future. The court may view these as marital property if they were granted during the marriage, even if they have not yet vested. This creates a difficult valuation problem. How do you value a stock option that is currently underwater, or has no market value today, but could be worth a significant amount in 3 years? A common mistake is to agree to a split based on the current value. You need a formula that accounts for the risk and the future potential, often involving a time rule formula that separates the portion of the asset that was earned during the marriage from the portion that will be earned after the separation. This requires precision. If you sign an agreement that is vague, you could find yourself paying your ex-spouse for growth that you earned entirely through your own labor years after the divorce is finalized. Then there is the issue of private business interests. If you own a portion of a business, or if you are a partner in a professional practice, you are looking at one of the most volatile assets in a divorce. The court will require a formal valuation of your interest. You need to hire a business appraiser who has experience in your specific industry. There are different methods of valuation, such as the income approach, the market approach, or the asset-based approach. Each method can produce a wildly different number. If your appraiser is too aggressive, you might overstate the value and end up paying a larger share of the marital estate to your spouse. If they are too conservative, your spouse's counsel will easily dismantle your position with their own expert. The historical trend in these cases shows that the battle is often fought between the two competing expert reports. The side with the more sound, defensible methodology usually gains the upper hand. Real estate equity is another area where men often settle for a poor outcome. You might assume that the current market value of your home is simply the listing price, but you must account for the cost of sale, the real estate commissions, the closing costs, and the capital gains taxes if the home is sold. Imagine if you are a homeowner in a suburb of Phoenix. If you agree to give your spouse half of the current equity, but you do not account for the 10% that will be lost in transaction costs when the house is actually sold, you are effectively paying your spouse more than they are entitled to. Always use the net equity, the amount that would remain after all expenses, as the basis for any division. If you are keeping the home, you must have it professionally appraised. Do not rely on a Zillow estimate or a comparative market analysis from a friendly real estate agent. You need a certified appraisal that can stand up to scrutiny in a court proceeding. Do not overlook the debt. Marital debt is just as significant as marital assets. This includes credit card balances, personal loans, and potentially even medical debt. If your spouse incurred a debt that was for their own benefit, and not for the benefit of the family, you need to be prepared to argue that it is their separate liability. However, be aware that many states apply a presumption of marital debt for any obligations incurred during the marriage. You must gather the statements and be able to trace the use of those funds. If your spouse went on a shopping spree using a credit card that is in your name, you need to provide clear evidence that this was not a household expense. This requires you to be methodical and document-heavy. You are building a case, not just a spreadsheet. This level of financial rigor is what separates the men who navigate the system from the men who are dismantled by it. You are shifting from an emotional narrative to a data-driven strategy. By treating your assets with the professional skepticism they deserve, you protect your retirement, your business, and your future earning capacity. However, even with a perfect balance sheet, there is one final intangible asset that remains the most contentious part of any divorce: the parenting plan. While we have focused heavily on the math, we must now pivot to the psychology and the logistics of shared custody, as this is the area where the most intense conflict and the most permanent damage is generated. In the next part, we will analyze the framework of modern parenting plans, how to build a schedule that prioritizes your children while preserving your own life, and why the language used in these documents is just as important as the numbers on your ledger. The parenting plan is the single most important document you will ever sign, carrying far more weight than your financial settlement. While bank accounts can be replenished and houses can be sold, the legal structure of your relationship with your children is often permanent until they reach the age of majority. In 2026, the American court system has evolved away from the traditional every other weekend model. Yet many men continue to settle for these limited schedules out of a misplaced sense of convenience or lack of awareness. You must view the parenting plan as a living document that requires the same level of strategic foresight as your career planning. The first trap is the concept of visitation. The very word suggests that you are a guest in your own children's lives. You must strive for a parenting plan based on shared parental responsibility and equal time, where the legal terminology reflects your role as a father, not a visitor. Imagine if you are a father in a suburb of Denver in 2026. If you agree to a standard visitation schedule because you believe it will be easier to manage with your work travel, you are failing to account for the long-term impact on your children's development and your own legal standing. Courts are increasingly moving toward a rebuttable presumption of equal parenting time, but you must advocate for it. If you do not ask for it, or if you agree to less, you are establishing a historical trend of lower involvement that can be held against you if a modification is ever required. The language in your parenting plan must be incredibly precise. Avoid vague terms like reasonable visitation or at the convenience of both parties. These phrases are invitations to litigation because they rely on the assumption that you and your ex-spouse will remain amicable for the next decade. If the relationship degrades, these terms become unenforceable. You need a detailed, granular schedule that covers not just the basic rotation, but also the holidays, school breaks, summer vacations, and the logistical details of transport. Imagine a scenario where you have a planned vacation with your children during the winter holidays, but because your parenting plan did not explicitly define the start and end times, you and your ex-spouse are left arguing over whether the morning of the 24th or the evening of the 25th is the start of your time. This level of conflict is exactly what drains your resources and destabilizes your children. You also need to account for the decision-making process. Legal custody is distinct from physical custody. Legal custody grants you the right to have a say in major life decisions regarding education, medical care, and religious upbringing. Many men concede this in the hope of reducing conflict, but this is a mistake. You have a fundamental right to be involved in the formative decisions of your children's lives. Your parenting plan should stipulate that these decisions must be made jointly, and it should include a dispute resolution mechanism, such as mediation, to be used before either parent can return to court. This structure forces a collaborative process and prevents one parent from unilaterally changing the child's environment. Consider the case study of a father in a Chicago suburb who allowed his parenting plan to be drafted with broad, loose language. He assumed that because they were currently on good terms, they would simply figure things out. When the children reached high school, a disagreement over which school they would attend became a protracted, 2-year legal battle that cost tens of thousands of dollars and created significant trauma for the teenagers involved. Had the original agreement contained a specific mediation clause and a clear framework for resolving educational disagreements, the conflict could have been managed through a neutral third party without ever reaching the courtroom. The lesson here is that you are not drafting for your current reality. You are drafting for the reality that will exist 5 or 10 years from now. Furthermore, you must prepare for the changing needs of your children as they age. A parenting plan that works for a toddler will not work for a teenager. You should build in a mechanism for periodic review of the schedule, tied to the child's developmental milestones or academic transitions. This is not about constantly renegotiating. It is about acknowledging that the child's life is dynamic. By building flexibility into the agreement, you avoid the need to constantly return to the legal system to address changing circumstances. This is a strategic advantage that demonstrates to the court that you are thinking in the best interest of the children, rather than fighting for your own perceived position. You also need to address the practicalities of communication and interaction. In the modern suburban divorce, there are numerous digital platforms specifically designed for co-parenting. These tools, such as Our Family Wizard or Talking Parents, maintain a permanent, unalterable record of all communications and scheduling between parents. Incorporating the use of these tools into your parenting plan is a proactive step that protects you from allegations of harassment or miscommunication. It provides the court with a clear, neutral log of how the co-parenting relationship is functioning, which is essential if you ever need to demonstrate that you are the parent who is consistently acting in the best interest of the children. We have now established the framework for your legal, financial, and parental strategies. You have learned how to audit your assets, select the right legal representation, protect your social and professional reputation, and construct a robust parenting plan. But there is one final critical element that often goes unaddressed until the very end: the transition to your post-divorce life. How do you actually execute the changes you have negotiated, and how do you build a new future that is resistant to the traps of the past? In the next part, we will discuss the endgame of your divorce, the transition from the courtroom to reality, and how to structure your new life to ensure that you are not just surviving, but actively building a stable foundation for the next chapter. The final decree is not the end of the divorce. It is the beginning of a complex, long-term post-divorce reality. Many men make the mistake of assuming that once the judge signs the order, they can simply flip a switch and return to their previous life. This is a profound misunderstanding of the systemic changes that have occurred. You are no longer living in the same economic, social, or household framework that you inhabited for the last decade. In 2026, the transition to post-divorce life requires a disciplined, structural approach to rebuild your foundation. Imagine if you are a suburban professional who just finalized a settlement that involved dividing your primary residence and reallocating your retirement funds. You are now working with a new budget, a new living situation, and a new set of long-term financial obligations. If you do not immediately begin to recalibrate your lifestyle, you will find yourself in a downward spiral of debt and social instability. The first step is a post-decree financial audit. You must take every single line item of your final settlement, your alimony obligations, child support payments, the split of your investment accounts, and the distribution of debt, and integrate them into a new, zero-based budget. This is not about cutting corners. It is about creating a sustainable model for your new financial reality. Historical trends in post-divorce outcomes show that men who struggle the most are those who attempt to maintain their pre-divorce lifestyle on a significantly smaller pool of assets and a reduced monthly cash flow. You need to identify where your expenses can be optimized. This might involve downsizing your housing, adjusting your personal spending, or reevaluating your investment strategy to account for the loss of assets. One of the most critical elements of this transition is the immediate update of your estate planning. A divorce decree does not automatically invalidate your previous will, your trust documents, your life insurance beneficiary designations, or your power of attorney. If you do not update these documents, you could be leaving your assets or your healthcare decisions in the hands of your ex-spouse, regardless of the court's decision in your divorce. This is a common oversight that can cause catastrophic consequences. You need to consult with an estate attorney to ensure that your beneficiaries are updated to reflect your new life, and that your legal directives are aligned with your current intentions. This is a protective measure that secures the assets you have worked so hard to retain during the division process. You also need to establish a new social and domestic routine. The suburban divorce often results in a loss of your previous social support system, as friendships are often divided along the lines of the marriage. This is not an indication of your personal failure. It is a structural reality of the suburban lifestyle. You must be proactive in building a new, healthy support network that is separate from your past. This could involve re-engaging with old interests, pursuing new professional development, or finding communities that are focused on personal growth and stability. The key is to avoid isolation. Men who remain isolated during the post-divorce transition are at a significantly higher risk for long-term health and emotional challenges. Building a new identity that is not tethered to your previous marriage is essential for your future well-being. Consider the case study of a father in a suburb of Charlotte who, post-divorce, found himself struggling to navigate the transition because he spent his evenings alone in an apartment, focused on the past. His lack of a new routine led to a decline in his professional performance, which in turn threatened his ability to meet his child support obligations. Once he made the conscious decision to prioritize his physical health, reconnect with his professional network, and establish a consistent routine that balanced his parenting time with his own personal growth, his financial and social stability returned. The lesson is that you must be the active architect of your new life. If you do not design it with intention, the circumstances of your divorce will continue to dictate your daily reality. You must also remain vigilant about your ongoing compliance with the court's orders. A divorce decree is a binding legal document. If you fall behind on your payments, ignore your parenting schedule, or fail to communicate according to the terms of your agreement, you are leaving the door open for future litigation. Many men assume that once the decree is signed, the court is done with them. In reality, the court remains involved through the enforcement of the agreement. Any breach of the decree can be used to drag you back into court, creating unnecessary expense and trauma for everyone involved. Maintain a meticulous record of your compliance. Keep your receipts for child support. Maintain your digital log of parenting time, and stay in strict adherence to every financial requirement listed in your settlement. This is your insurance against future disruption. Furthermore, you need to prepare for the inevitable changes in your life that will require a modification of your orders. Your income might increase or decrease, your children will grow and require different levels of support, or your living situation might change. These are expected events. The most effective way to manage them is to have a clear, proactive strategy for how to handle these changes, typically through mediation or legal consultation before they become sources of conflict. If you anticipate a change, address it with your ex-spouse through your professional channels before it reaches a point of crisis. By managing these transitions as business decisions rather than emotional battles, you retain your control and keep your costs low. You are now looking at the final structure of your post-divorce foundation. You have built a plan that secures your assets, protects your future, and provides a framework for a stable, healthy life. But there is one final, overarching theme that ties this entire deep dive together: the psychological and philosophical shift required to thrive, not just survive. How do you integrate the lessons of your divorce into a life that is truly your own? In the final part, we will discuss the mindset, the long-term vision, and the strategies for maintaining your composure, your autonomy, and your growth in the years to come, ensuring that your suburban divorce becomes a starting point for a better chapter, not a permanent marker of your past. The philosophical shift required to thrive after a suburban divorce involves moving from a reactive mindset to a proactive, outcome-oriented framework. For years, you have likely been navigating the world based on the expectations of others, the norms of your neighborhood, and the social requirements of your marriage. The divorce process shatters these constraints, which, while painful, offers a rare opportunity to rebuild your life with intentionality. Imagine if it is late 2026, and you are evaluating the choices you made over the last 18 months. The men who emerge the strongest are not those who spent their time looking for someone to blame, but those who performed a cold, objective assessment of their own role in the collapse, and used that knowledge to change their future behavior. This is not about self-flagellation, it is about radical accountability. You must understand that the legal and financial systems are only one side of the coin. The psychological side is where the long-term work happens. The suburban middle-class culture often encourages a quiet, stoic approach to internal challenges, where men are taught to suppress their struggles and project a seamless, trouble-free exterior. This suppression is a recipe for long-term stagnation. You need to cultivate an internal dialogue that is driven by data and growth, rather than resentment and justification. If you continue to view yourself as a victim of a broken system, you cede your power to the court and to your ex-spouse. Instead, view yourself as an individual who is currently restructuring his life to be more resilient, more autonomous, and better prepared for the future. Case studies of men who have successfully navigated this transition highlight a common pattern: the adoption of high-level discipline in their personal, physical, and professional lives. This is not about overcompensating. It is about establishing a high baseline for your personal performance. This means taking your physical health seriously, not just as a vanity project, but as a primary pillar of your ability to handle stress and maintain clarity. It means investing in your professional development, regardless of your seniority, because in a world of rapid economic shifts, your human capital is your only true insurance. When you have a solid professional foundation and a high degree of physical and mental resilience, you are less vulnerable to the external pressures that can derail less prepared men. Another key aspect of this growth is the refinement of your social environment. You have likely realized through this process that many of the relationships you held were situational, tied to the lifestyle of your marriage rather than the reality of your individual self. This is an opportunity to curate your social circle. Surround yourself with people who prioritize integrity, competence, and long-term goal setting. Avoid individuals who thrive on gossip, drama, or the perpetuation of conflict. Your social environment is a major contributor to your psychological state. If you are constantly exposed to negative influences, your ability to maintain a rational, strategic mindset will be compromised. Be selective. Your time is a finite resource, and it should be invested in relationships that contribute to your overall stability and personal development. Consider the concept of long-term vision. Most people drift through life, reacting to the immediate demands of their jobs, their children, and their domestic responsibilities. A suburban divorce forces a reset. You now have the chance to write a new mission statement for your life. What are your core values? What do you want your life to look like in 5, 10, or 15 years? When you are clear on your objectives, the daily irritations of co-parenting or financial adjustments become minor obstacles in a larger journey rather than life-altering events. You are no longer living for the weekend or for the next holiday. You are living for the execution of a long-term plan. This creates a sense of agency that is immune to the ups and downs of litigation or social pressure. The integration of these lessons is the final step in your transformation. You are not forgetting the past, but you are choosing not to let it dictate your future. You are acknowledging the systemic realities of the American divorce system, accepting the financial and legal parameters you have been forced to navigate, and using them as a training ground for a more disciplined life. This is the difference between a man who is defined by his divorce and a man who is defined by his recovery. The latter is a man who understands the game, knows the rules, and plays with a focus that no longer allows for the influence of external chaos. Understand that there is no shortcut to this level of clarity. It comes from the consistent application of these principles over time. You have now audited your finances, secured your legal position, optimized your parenting plan, and transitioned into a new stable routine. You have faced the most intense systemic pressures of the suburban lifestyle and have, through the application of strategy and discipline, retained your autonomy. But there is one final overarching thought to consider. You have been through a masterclass in survival and rebuilding. What happens now that you have all the knowledge, the tools, and the perspective? What is the final decisive action that cements your transition from the old life to the new? In the final part, we will discuss the synthesis of this entire series, the ultimate roadmap for long-term maintenance of your new foundation, and the final piece of advice that will ensure you remain the architect of your own future, regardless of what the system or your circumstances throw your way next. The final piece of this masterclass is the internal commitment to sustained vigilance. You have built a framework that covers your legal, financial, and psychological security, but the system of suburban life, with its inherent pressures and societal expectations, is designed to push you back into old patterns. You must understand that your divorce was not an isolated event. It was a catalyst for a permanent change in how you manage your existence. Imagine if it is 2026, and you are standing at the end of this process. The greatest risk you face now is complacency. The moment you decide that you have done enough, that you can stop auditing your finances, that you can relax your boundaries, or that you can stop prioritizing your children's needs over your own convenience, is the moment the structure you have built begins to weaken. Sustained stability requires a routine of periodic review. Just as you perform a maintenance check on your home or your professional equipment, you must perform a maintenance check on your life. This means reviewing your financial situation every quarter to ensure your budget is still aligned with your income and your support obligations. It means reviewing your parenting plan once a year to ensure it still meets the developmental needs of your children. It means checking your estate plan to ensure your beneficiaries are current. You are managing a portfolio of life assets, and like any portfolio, it requires active management. Do not fall into the trap of believing that because you survived the legal battle, the work is over. The work is now the practice of your own resilience. Case studies of men who have successfully transitioned to long-term post-divorce success demonstrate a common focus on the concept of high-performance stability. They do not operate on the edge of financial or emotional ruin. They build in margins. They keep an emergency fund that is not just for taxes or car repairs, but for the unexpected legal expenses that can arise from future disputes. They maintain their professional skills at a level that ensures their income remains competitive, regardless of the economy. They build social circles that are not dependent on their previous relationship status. This is not just about protection, it is about empowerment. When you operate with margins, you do not panic when a situation changes. You respond with the calm, data-driven methodology you developed during this masterclass. Another vital component of your ongoing strategy is the continued cultivation of your parental relationship. You have established a legal parenting plan, but the legal document is only the floor, not the ceiling. Your role as a father is to provide your children with the stability, the values, and the emotional support they need to navigate their own futures. This requires a level of patience and focus that is independent of your relationship with your ex-spouse. If you allow your co-parenting relationship to be defined by conflict, you are missing the opportunity to be the source of calm in your children's lives. Your children should know that when they are with you, they are in a space that is focused on their growth, their education, and their well-being, free from the background noise of the divorce litigation. This consistency will be the most significant factor in your long-term relationship with them. You must also be prepared to encounter and navigate new challenges. Life is unpredictable. You may experience career changes, health issues, or economic shifts. In the context of your post-divorce status, these events can feel more threatening because you are essentially starting from a new baseline. However, you now possess the analytical skills and the strategic framework to handle these threats. You know how to gather data, how to consult with experts, how to maintain a professional demeanor, and how to protect your assets. When the next challenge arrives, do not view it as a repeat of your divorce. View it as a test of the foundation you have built. If you have done the work, you will find that you are capable of navigating the challenge with a degree of control that you never thought possible. Ultimately, this masterclass is about the evolution of the suburban man. The traditional suburban model often incentivized a passive approach to one's own life, where one relied on social and domestic structures to provide stability. That model is no longer available to you in the same way. You are now a man who understands the systems you live within. You are a man who takes full responsibility for his own outcomes. This is not a burden. It is a profound form of freedom. You are no longer waiting for someone else to secure your future, to validate your decisions, or to provide you with the structure of your daily life. You have the knowledge and the discipline to build that structure yourself and for the people who depend on you. As you move forward, keep the lessons of this series at the forefront of your decision-making. Protect your privacy, stay focused on your professional and financial goals, maintain your physical and mental health, and always lead with a strategy that prioritizes the stability of your children. Do not be distracted by the opinions of others or the emotional noise of the past. Your focus should be on the execution of your long-term plan. The life you are building is a reflection of your own agency and your own resilience. You have navigated the most complex systemic challenge a man can face in the American suburban landscape. You have taken the information, you have applied the structure, and you have come out the other side with a foundation that is capable of supporting a future defined by your own choices. Carry this knowledge with you. It is the most valuable asset you have acquired during this transition. You are now equipped to handle not just the aftermath of your divorce, but any challenge that comes your way. Your journey does not end here. It merely transitions into a new phase where you are finally the one in command of the trajectory of your own life. Use the tools you have, keep your standards high, and never stop building.